Good afternoon, everyone, and welcome. We're pleased to have you with us today. Originally, we had 4 cases set on the afternoon docket, but 1 case has been continued. Thus, the other 3 cases will be heard in the order in which they appear. As you may know, the Court of Appeals of Tennessee is one court, and all 12 judges hear cases across the state, regardless of whether we're from the East, Middle, or West Division. And we're honored today to have Judge Christy Davis from the Eastern Division sitting with us. And next week, Judge McBrayer from the Middle District will be sitting with her in Knoxville. So we're moving around, but we're honored to have her with us today. Let me remind counsel that each side has a total of 15 minutes for your argument, and that applies whether there's one lawyer or multiple lawyers arguing. If multiple lawyers argue, you will need to divide that 15 minutes between or among you. The appellants have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please let us know how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Victor Daniel Medina-Tratel versus Christopher Holloway et al.
Good afternoon.
Good afternoon, may it please the court. My name is Jim Stocks. I'm here on behalf of the appellant, Mr. Medina. He goes by Mr. Medina as opposed to the Medina-Tratel. So that if you hear me talk about him, that's how I'm going to refer to him today.
Very good. And if you would speak up just a little bit, I'm slightly hard of hearing.
I got my hearing aids here, so I'm there with you.
Well,
so
we'll just, if we yell at each other, we're not angry.
okay. If I start yelling, I apologize.
Okay. Well, Judge Davis will put you in your seat. So. Please proceed.
Well, Your Honors, we're here today in an action that's for independent torts committed under Tennessee law that were committed in Wilson County, Tennessee by 2 individual defendants who are Tennessee residents, an intervening defendant who did business in Wilson County, Tennessee, against a plaintiff who's a Tennessee resident, all of that in violation of Tennessee law. And there's 3 significant results of that, or there's three purposes for which that's significant. The first one is it shows that venue was proper in this action. Under Tennessee Code annotated 24101, this was a transitory action. So the events happened in Wilson County, action was filed in Wilson County, venue was proper. The second purpose, or second reason it's significant, is it demonstrates that the forum selection clause in the LLC agreement that the trial court applied to dismiss this case didn't apply. When you look at the language of the LLC agreement and the venue selection clause at issue, in interpreting that language, courts have to give it the usual, natural, and ordinary meaning. Here that language said the venue for any dispute arising under this LLC agreement, or any disputes among members of the company will be in the county of the company's registered office, which is all the way down in Oconee County, Georgia. Now the usual and ordinary meaning of that language is that anything that arises under the LLC agreement, or if there's disputes between the members about the LLC agreement, you got to go down to Georgia. That's perfectly to be expected. But what's not ordinary, what's not reasonable, is to extend that to any potential causes of action, any independent torts that are committed here.
The language that's sort of looking at the second part of the forum selection language, I thought I heard you say about the LLC agreement, but why is that part of the forum selection clause? And isn't it stated more broadly here in terms of essentially any dispute between members here? I'm not saying it's a great provision to sign, but isn't it stated in sufficiently broad terms that it could essentially include any dispute?
Well, Your Honor, I think that goes to the usual, natural, and ordinary meaning. I would submit that a person reading that, giving it its usual, natural, and ordinary meaning, when they think of that in the context of signing an LLC agreement, wouldn't think that they're signing away any potential cause of action just because it happens to be between people who happen to be members of this LLC. Under such a broad language, for example, if one of the members was to, at a social gathering having nothing to do with the LLC, was to strike another member, any cause of action for assault, for battery, would have to be brought all the way down in Georgia. That's not, I would submit that's not the usual, natural, and ordinary meaning. And particularly here where, again, these are Tennessee torts that were committed here in Tennessee. The usual, natural, and ordinary meaning of that language, your average person is not going to think that means, okay, we're doing business up there in Tennessee, you commit fraud against me, I got to go all the way down to Georgia, even though all the business is being done up there, we all live up there, we got to go to Georgia to litigate whether or not you defrauded me.
But the torts in this case arose specifically because of the business relationship that they had.
It did arise in the context of the business relationship, yes, Your Honor. But again, it didn't arise under the terms of the LLC agreement itself. Contrary, as we'll
I
get.
think you may have an argument for that under the first section, but maybe not under the second. I think it's more difficult. Arising under this LLC agreement is one thing, and as Judge Usman pointed out, any disputes among any members of the company is another.
Correct, but again, I would submit that the ordinary meaning that people would, when they're signing that agreement, would think, okay, if we've got a dispute about the LLC agreement itself, or some provision in that LLC agreement.
Counsel, in your reading, how would you distinguish the first and second part there? How does, and you sort of gave the about the LLC understanding of the second part. What's the difference in meaning between part one, arising under, and the second component, among members? Or are you saying they mean the exact same thing? Both components of the forum selection clause have the same meaning?
I think it's tying the two clauses together that gives it the meaning that this is about the LLC. It's not about separate torts that may be connected to the LLC somehow, but it's not something that the LLC specifies.
Well, isn't this about ownership of the LLC and $100,000 out of the LLC account, those two claims?
The tort claims are based off of misrepresentation.
Regarding the sale of
Correct.
25%
Correct.
of the LLC membership.
Correct.
Okay.
So it does touch on the business.
I would say that touches on it, the ownership.
But the underlying, the action that happened wasn't, we didn't bring a cause of action saying you breached the LLC agreement by doing A, B, and C.
Right.
We said you defrauded us.
You misrepresented
You
that
misrepresented.
you were going to sell to me 25% of the membership.
Exactly, Your Honor. So I would draw that distinction between committing an actual tort versus something that's contractual in nature, which when you sign an LLC agreement.
Well, is there any doubt that the $100,000 cashier check that came out of the LLC corporate account, that pertains to the LLC, doesn't it?
Correct. That came out of the LLC's,
So
the business account.
If we weren't to enforce the venue selection clause completely, then arguably you would have a lawsuit over the $100,000 in Georgia and the lawsuit over the 25% ownership misrepresentation in Tennessee.
Arguably, Your Honor.
You'd have
Yes.
two trials in two different states. Okay. And then we haven't even gotten to the part of the lease dispute.
Yes, and then the $100,000 was interpleaded in the context of the business being shut down, wanting to make sure it wasn't, that neither side was taking that money and running with it, so we put it in the court. It was
Well, your client took the money to make sure the others didn't take the money, and your client properly
Correct.
impleaded it
Correct.
into the court's account.
Correct.
Okay.
Correct, Your Honor. So that's the second way I think that the fact that all this stuff happened here in Tennessee comes into play. And the third is that even if the forum selection clause did apply under the terms of the LLC agreement, it shouldn't be applied here. The facts of this case are very similar to the Dyersburg Machine Works case, which looked at the factors that you look at to determine if it's fundamentally fair or not to enforce.
Is there anywhere you can point the court to where that argument was advanced before the trial court, that this was not a scope argument, but a convenience argument? What was that argument made before the trial court?
Well, I think it's part of the argument that we made, that this was a Tennessee tort. It's by Tennessee residents against a Tennessee resident for torts that happened here. And part of our argument was, under the applying the forum selection clause, we'd have to take everything all the way to Georgia. So, in that sense, yes, convenience was a part of it. Did we specifically say the word convenience? No, but I don't think we have to specifically say that word when we're arguing the gist of this argument. And,
There's two different questions, though, whether it's within the scope of the agreement versus whether, even if it is within the scope, it's an inconvenient forum in which to litigate the case. I mean, those strike me as two different legal questions. It could be within the scope, and we could all say, yep, this absolutely fits, but it's an improper forum to litigate it in Georgia anyway. And aren't those two different, distinct legal questions?
They may be distinct legal questions, but I think they can be addressed in the same, by making one argument. You're drawing both issues into play. Both that it doesn't fall within it, and we shouldn't have to go all the way to Georgia to litigate something that's Tennessee law, that's involving Tennessee.
Was it clear to the trial judge that was that issue in this case, in terms of the actions trial court was taking, that there was a convenience argument being made here? And is there anywhere in the ruling,
I can't get into
is there
his
a
head,
ruling you can point us to and say the trial judge was considering convenience, understood your argument as
Right.
including the convenience argument, and ruled on a convenience argument?
all I can say is the word convenience wasn't specifically in the order. So I would argue that yes, it was included, but I can't point to the order itself and say that word was included. But if you look at the Dyersburg case, the factors that they looked at, in that case, the witnesses would have all been Tennessee residents. The parties were all Tennessee residents. One of the businesses involved was qualified to do business in Tennessee. The distance from where the plaintiff was located to where the action was brought in Tennessee was only 35 miles, versus if they'd enforced the forum selection clause, it would have been 500 miles to go up to some part of Kentucky. Yeah. Similarly here, we're all, the individual parties are all Tennessee residents. The LLC, which intervened into the case, sought to get in the case. It was doing business here in Tennessee. And the location is certainly far, far removed from the convenience of everybody coming right here into Wilson County, Tennessee, where the business was, and where at least one of the parties lives, and the other one lives, I believe, just over the border in Rutherford County. Again, that's the third way I would say that those factors come into play. And that's before we even get to the issue of the unclean hands. And I think the unclean hands not only should act as a bar to dismissal of the case here, but it also goes to reinforce all those 3 points that I just talked about. Because when the LLC and when Mr. Holloway had an opportunity to bring claims that they brought specifically under the LLC agreement. We didn't bring anything specifically under the LLC agreement. They did in a separate claim against Mr. Medina. They did it in Wilson County, Tennessee Circuit Court. after
Now,
they had
is
already
that-
argued.
Is that the one that's related to the landlord's breach of lease?
Correct, Your Honor, yeah.
So it's a counterclaim, cross-claim?
It's a
Or
they're cross claims, Your Honor.
Yep,
Yes.
okay,
And I don't represent Mr. Medina in that action, but my understanding is that that's an action brought by the landlord against Mr.
Right.
Medina, Mr. Holloway, and the LLC.
Right.
And then the LLC and Mr. Holloway filed cross claims with their answer. I believe it was brought up from General Sessions to Circuit.
Basically, the defendants in the landlord case are saying nobody owes the landlord anything, but if we do, he owes it.
Correct. And they're specifically alleging fraud, similar, causes of action to what Mr. Medina brought, but they specifically say it was fraudulent under the terms of the LLC agreement. They did that here in Wilson County after having argued that we couldn't do it. So we would submit, again, number one, that demonstrates unclean hands and they should not be allowed to.
But what option do they have if the landlord sues them in Wilson County? They can't drag the landlord down to Georgia, but they have the right to defend themselves and seek indemnification in that action. So,
Well, our argument, I guess, would be if the LLC is going to apply, then they need to bring an action down in Georgia. If they're going to, what's good for the goose is good for the gander, so to speak. If they're going to hold our feet to the fire, they can't just months later turn around and specifically cite the LLC. Not
The filing in that case is after the decision in this case?
correct, Your Honor. Our decision was October. I don't have the exact date in my head, and they filed in March of the following year. So yes, it was just months after having this case come down.
But they can't bring the landlord to suit in Georgia. And they would have no basis for suing the landlord in Georgia.
Well, I would submit they don't need to have the landlord down there. If there's a judgment that's entered against them here, they can still bring an action in Georgia against Mr. Medina for fraud or for whatever their causes of action happen to be. But if it needs to be done in Georgia under the terms of the LLC agreement, and they want us to do it, they need to do the same thing. So I see my time's up.
all right, we'll hear from you on rebuttal. Thank you. We'll now hear from the appellees. Will you be sharing time or?
I will, Your Honor. That's one of the first things I'm going to address.
Thank you.
May it please the Court, my name is Miles Martindale, and I represent the appellee Catch-22 Nashville LLC. I'd like to reserve 10 minutes for my initial argument and then 5 minutes for argument for Mr. David Rich on behalf of the Holloways. And Mr. Rich will specifically address the unclean hands in the motion for consideration of post-judgment facts.
Very good, thank you.
Just as a brief intro, this case is about a jointly owned restaurant business, Catch-22 Gastro Pub, located in Mount Juliet, Tennessee. Mr. Medina brought this lawsuit over a dispute in ownership interest in the LLC. Specifically, he alleged that Chris Holloway made some fraudulent misrepresentations to him when discussing the buyout of two former partners. Medina also interpled funds after receiving a eviction notice from the landlord. He fired the employees and shut down the business, and the next day went to the bank and took those funds out and interpled those funds into the court. These were corporate funds, and there's no dispute over that. Although Medina claims this is an independent tort action, this dispute is undoubtedly about the parties' ownership interest in Catch-22 LLC and corporate funds. The appellants filed motions to dismiss on the basis of the formal selection clause within the LLC agreement, and the trial court granted these motions to dismiss. It's our position that the trial court correctly granted these motions to dismiss based on the clear language of the form selection clause. We maintain our positions asserted in the motions to dismiss that we filed during the trial court proceedings. Counsel references Tennessee Code annotated 24101 with regard to venue, and I think that language is actually helpful because it carves out an exception specifically for this instance. The language says, in all civil actions of a transitory nature, unless venue is otherwise expressly provided for, the action may be brought in the county where the cause or action arose, or in the county where the defendant resides or is found. Key language in there is unless venue is otherwise expressly provided for. In this case, we have an LLC partnership agreement where it is expressly provided for, clear and unambiguously.
I know that you cited the statute, and I know it's in the record, but would you remind me, what's the number on that statute?
It's 24101, Your Honor.
Thank you. Okay.
The trial court correctly dismissed plaintiff's claims against the defendants because the court recognized the applicability of this exception language within the statute and held that the forum selection clause covered any disputes between the members of the LLC. As pointed out in our brief, an LLC operating agreement is an enforceable contract between its members.
Counsel, is that a fair understanding of the party's intent? I mean, any dispute between the parties, and you get in a traffic accident or you have a fender bender with each other, and is that subject to being, it has to be litigated in Georgia instead of here in Tennessee?
Your Honor, I think that's a fair question. I think how I would distinguish it in this case is we're not dealing with a slip and fall accident at an owner's house. We're not dealing with some motor vehicle accident that happened outside the context of their relationship within this business organization. This is directly related to the ownership interest in the LLC. And so I can understand how something more remote might not fall under the original intent of this agreement. However, it's our position that the original intent of the parties would be that anything that fell within the operation of this LLC and any dispute between the members about the operation or the ownership interest in this LLC would fall under this forum selection clause. It's also important to point out that, as Your Honor did, that the plaintiff never raised any issues as to the validity of and enforceability of the LLC's forum selection clause, nor did they raise any argument about the fairness or inconvenience of the forum selection clause. It's nowhere in their response to the motion to dismiss. There is nowhere that they can point to in the record to show that they ever raised this before they filed their brief.
Opposing counsel suggests that it's implicit when you're making argument in terms of scope and you're essentially saying, well, everybody's here, that you're implicitly making an argument as to fairness. Why isn't that enough?
Because Your Honor, I think a reflection of their filing shows that there really was no reference to inconvenience or unfairness or any argument whatsoever. And so I think that, frankly, I was shocked when it didn't come up. In forum non-convenes, I mean, any iteration of that type of argument, there's no reference in their motion whatsoever to that. They essentially just say that, listen, it doesn't arise under the operating agreement or arise under this LLC agreement, and that these torts are separate and apart from that, and without any reference to really the unfairness of this forum selection clause. They hinge their argument on this is separate and apart from, it doesn't arise under this agreement. They essentially try to say that if it's not within the four corners of this agreement or a dispute over this agreement particularly, that it doesn't apply. That's what they kind of hinge their argument on, and there's no reference whatsoever to any inconvenience or fairness argument. And so it's our position that that has been waived. If you look at the clear language of the section 1.09 of the LLC agreement, it says, any dispute arising under this LLC agreement or any disputes among any members or the company will be in the county of the company's registered office. Yeah. It doesn't say, as counsel indicates, it says nothing about the LLC agreement. It has no such language. It is broad. It is all-encompassing. It says, or any dispute among any members. And while he may say, well, it wasn't contemplated as we previously talked about, motor vehicle accidents or things so remote, this is not what we're dealing with in this case. This case is about ownership interest in the LLC and corporate funds. It directly relates to this entity.
Well, if we took this argument to the extreme, two of the members of the LLC are husband and wife, Christopher and I can't remember her first name, Mrs. Holloway. If we interpret this strictly, they'd have to go to Georgia to get a divorce. So there has to be some limitation.
Yeah, yes, Your Honor, and I think that you know, to the only way that I could see that applying is that it would essentially be a division of that equity ownership would be the only ties. But that certainly would fall under the, I don't do family law, I'll be the first to admit that, but the equitable division of property, if my law school serves me correctly. But we still wouldn't, we don't.
I imagine the court in Georgia would be quick to say, no, we're not going to handle the divorce down here, but anyway.
Again,
sorry I got off on that.
That's okay. Our position is that we're not dealing with a remote instance in this case. This is directly on point. It's about the ownership interest. It's about corporate funds, and so we believe that the plain language of the 1.09 section of the LLC agreement is applicable in this case. They cite the Dyersburg case repeatedly throughout their brief, and we believe that it's distinguishable in several ways. First, the defendants in that case was attempting to enforce a form selection clause on a third-party beneficiary of a bond. It wasn't somebody that had any part of the initial negotiating or drafting of that initial agreement that was being sought to be enforced on them. And so that's not the case here. Second, the court noted that the plaintiff would not be able to acquire jurisdiction over the ultimate debtor in that case. That's not the case here. All the parties are parties to that LLC agreement. And so this isn't a situation where there is this outside entity that complicates the corporate funds and the tort claims brought by Mr. Medina. In section 1.b or 1B of the appellant's brief, plaintiff asserts that the LLC agreement's form selection clause should not be enforced because it was unfair or would be inequitable to do so. This is the first time the plaintiff has raised this particular defense to the enforcement of the LLC form selection clause, and it's our position that plaintiff has waived that argument. Plaintiff's claims are subject to the LLC agreement's form selection clause enumerated in section 1.9, and Wilson County, Tennessee is an improper venue for plaintiff's action. Respectfully, the appellees request that this court affirm the trial court decision to dismiss the plaintiff's complaint and hold that the form selection clause is enforceable in this case and return the corporate funds, which are undisputedly Catch-22 Nashville LLCs.
All right, thank you very much. We'll hear from the other appellee.
May it please the court, Your Honor, Dave Rich of the Nashville Bar, and I'm kind of following along with co-counsel's arguments. When I say he's co-counsel, by the way, he represents Catch-22, the corporate entity, and I represent the Holloways individually. Specifically, Your Honor, this case is squarely about whether or not it's okay if a disgruntled member of an LLC who has authorization to use corporate funds to purchase things like food for a restaurant or cleaning supplies goes ahead and uses that authority to go down to the bank, take all of the money that the company has out of the bank, go down to a lawyer's office, and then implead all of those funds into the court, thus seizing the company basically and causing it to fail. As we stand here today, my clients, Chris and Melanie Holloway.
Hadn't the landlord already shut down the business?
And yes, Your Honor, actually no, excuse me. If you're saying, if the chronology you're asking is was the company shut down before the money was taken, I would say they all kind of happened.
Hadn't the landlord evicted the restaurant
before? There was an intention and letters written by the landlord to Catch-22. And that's what's going on, Your Honors, is that this member who's disgruntled, who has no place in the company to communicate about a corporate lease, the company has corporate attorneys down in Georgia, goes out of turn and goes ahead and starts dealing with this potential landlord and does so to the detriment of the company deliberately because he's disgruntled.
Potential landlord?
Well, we argue that the actual way that the landlord came into ownership of the property is that he came into it subject to the rights that Catch-22 had under its lease agreement, and those were ongoing. And Catch-22, as far as Chris and Melanie Holloway argue, never breached this lease, and so they were wrongfully evicted. And that's precisely why, and kind of the main thrust of why I'm here and presenting, is to deal with that unclean hands argument that was raised by Mr. Medina. And the point of why we sued the Holloways along with Catch-22 cross-claimed. So Mr. Medina is already a defendant along with Catch-22 and Mr. and Mrs. Holloway, and they're sued by the landlord. And the Holloways, in response, are saying, you, 615, worked with one of our disgruntled ex-members to go ahead and bring this company down. Now, why didn't we sue Medina down in Georgia about this? And the reason why is it was raised by Justice Davis, is that we need 615 to be a part of those proceedings. We're saying, oh, yes, Your Honor.
A more foundational question.
Sure.
Should we appropriately consider that fact, even the filing? And this is after the judgment, right? That this subsequent litigation, is that appropriately before this court?
I do not think it is, Your Honor.
Why not?
Well, number one, Your Honor, because what's before the court is this interpleading of funds and whether or not Mr. Medina has jurisdiction and venue to raise these claims against his fellow members of the LLC. That's what's before the court. The stuff that occurred in the lawsuit that's currently pending right now has yet to come to fruition. There are competing motions to dismiss in the case that have not yet been addressed by that court. And if there is an argument about waiver, if there's an argument, because right now my argument would be that Chris and Melanie Holloway have, for purposes of protecting their claims, filed this cross-claim, because the nature of that litigation, if it plays out at trial, is they're going to say 615 wrongfully worked with one of our members to bring this company down. And then that would beg the question of the jury, well, why don't we get to assess any fault or liability against Mr. Medina? And the other problem is that even if we want to have that argument, we can't do it in Georgia because 615 has never availed itself of any jurisdiction of Georgia. So we had to file that lawsuit. So respectfully, Your Honor, I would say these issues are not before the court. Let this all go forward with that litigation, but the two have nothing to do with one another. And I would just close with this, Your Honor. It brought the company down that this disgruntled member took this $100,000 out. And a part of the lower court's order, principally the first point of the order, was that this money needs to go back to the company. This is corporate assets, and this is not what you do when you're a disgruntled member, is that you seize all of the corporate profits and corporate property to go ahead and put it in a courthouse so that the business closed down, so you get back at your other partners. Specifically, that is what we asked to do. Number one is that the funds be returned and that the lower court's decision be affirmed and that this matter be dismissed.